You have questions, we have answers. This is Jane Miller.
And this is Ken Miller. Welcome to our show, all about real estate with Ken and Jane. Today we are joined by Kassidy, Klink, and Jacqueline Ulrich. They're environmental professionals with Peak Environmental. And we want to recognize and thank Peak Environmental for being a big sponsor of the East Brunswick Regional Chamber of Commerce. And we want to welcome you both to our show.
Thank you.
Thank you very much.
You know, since we know each other for a long time, I mean, the way I got to know your company is every time the township or the community needs something, you guys sponsor. That's how I get to know you. You know, always contribute, always give back to the community, which is great. I mean, we
really appreciate it. The chamber appreciates it. So we're going around, we're interviewing all the big sponsors of the EBRCC, including Peak. So when we want to give you guys airtime, not only are you a good sponsor, but you're a great firm who I personally use for some of my commercial deals, and you guys do a top-notch job for all environmental phase 1s, phase 2s, and all the other stuff we're going to talk about. So,
no, thank you so much.
Thank you.
Definitely want to support our community that our office is in, and it's our pleasure.
Thank you. Thank you.
So we're going to talk. I know we're back to the real estate now. Last week we had on a different topic, balloons, and but now we're talking about
jazz.
Now we're tying this really ties into what we do. So
everything tied in. This one more
this
related.
Ties in related directly to this. Whenever you deal with real estate, you deal with land, and when you deal with land, you deal with environmental issues, whether it's residential or commercial. So we're going to talk. Obviously, there's so many things that environmentally can pop up. We're going to cover some of the the basic bread and butter things, and let's talk about what a phase 1 environmental site assessment is for the listeners out there, and why it's important to do one when you're buying a commercial property, and oftentimes even with a residential to a very limited degree. So we want to talk about that first.
Sure, yeah. A phase 1 environmental site assessment, also known as a phase 1 or an ESA for short, is an evaluation of a property where you're trying to identify if there's any recognized environmental conditions. So things where there's the presence or the likely presence of hazardous substances or petroleum products that could indicate a release on the property, either currently or in the past, or even a material threat of a release. It also covers additional things like business environmental risks, asbestos-containing material, radon, lead-based paint, things like that. So it's really just to evaluate the property before you take ownership of it in order to qualify as an innocent purchaser under CERCLA, which is also known as the Superfund.
Right. Yeah, because this issue came up personally where let's talk about the innocent purchaser defense and what that entails. Because if you don't do, let's say the seller of a commercial property has a phase 1, the buyer, that's recently done, and if the buyer were to rely exclusively on that, even though the phase 1 wasn't the property of the buyer, that may be an issue with this innocent purchaser defense. So let's talk about why it's important that the buyer or the would-be buyer of a property do their own independent phase 1 and not exclusively rely on a phase 1 that was done by the seller or another third party.
Yeah, definitely a mistake.
Yeah.
Right.
I think it is important to hire your own consultant rather than relying on another one, because sometimes a seller may retain a consultant and it may be a little more glass half full than perhaps the site actually is. So you always want to make sure you're having someone, an independent party, unrelated to the seller of the property, to do your own due diligence. When you retain your own consultant, then you qualify as an innocent purchaser. If everything comes back okay and say down the road you find that there's an issue on the property, at least you've done your due diligence to inspect it and do the full assessment of the property in advance.
Mm-hmm. And what does the innocent purchaser entail? That would mean if they find contamination on the site after the buyer has bought it, but if they can show that they did a phase 1 hiring an environmental company and they did it per the ASTM standard phase 1 methodology, if there is contamination, then they're absolved by the state or the DEP of any liability for the cleanup. That's kind of what it's leading to?
Yeah, so a phase 1, it protects you at a federal level. In order to comply with innocent purchaser at the state level, you would prepare a preliminary assessment report, otherwise known as a PAR. So a lot of times what purchasers of commercial or industrial properties do is a combination report. So it's a phase 1 combined with a PAR, And then that way you're covering your state and your federal bases as an innocent purchaser. So then down the road, if let's say there's no concerns identified where you have any reason to think that there's contamination at the property because you checked all the records, you inspected the property, you did everything you need to do, and then let's say you go to redevelop the site and you find underground storage tanks or buried drums or something that you had no knowledge to be there, then you would qualify for some funding to help clean that up.
Right, and liability in New Jersey is joint and several. So if you don't do proper due diligence and don't have innocent purchaser protection, you could get sued. You can get wrapped up in that old contamination that you really had nothing to do with, and they can go after you. So you don't want your name listed on that list of who might be potentially liable for a contaminated property.
So with commercial property, I guess it's pretty fair to say that you pretty much, phase one is like the bread and butter. You don't buy that's like the basic no-brainer. Everybody's buying commercial property of any type. You're going to do phase one because you want to find. Maybe let's talk about, for the listeners out there, we kind of touched upon it, what a phase one entails. Obviously, you can talk about the fact you're doing a physical site visit, talk about the records review, what databases you search, talk about the Oprah requests you make to the town, so people realize what's involved. It's a lot of due diligence work involved in the phase one.
Yeah, I think oftentimes people underestimate the level of effort to prepare these reports until they receive a document that's 500 pages, and they realize that there is a lot that gets reviewed. So we submit requests at the local, county, and state level to see if there's any records that could be environmentally relevant, to develop the history of the site and kind of understand what it was formerly used as. We obtain databases that have so much information about tanks or spills, just various things that could have happened in the past at the property. We review old maps, which are very helpful, called Sanborn Fire Insurance maps. They have so much information like tanks and uses on it. City directories, which are like old phone books, essentially, that give you the different business names. There's a visual inspection of the property. It's non-invasive. No one's going in and taking any samples at this initial stage, but it's just a visual observation to look for evidence of spills or issues. And everything just gets put together. You interview people while you're on site. You make phone calls to interview people, and then you take all the pieces of the puzzle and put it together. And then you come up with your conclusions of whether there's recognized environmental conditions or not.
Right. That's the buzzword in the industry, recognized environmental conditions, right? That would lead to things. And what are some examples that could be recognized environmental conditions like that could come up, like evidence of distressed vegetation maybe, or evidence that there was an underground storage tank, or what are some other things that typically come up in the phase one that would warrant, I guess the phase two, further, soil or groundwater investigation?
Right. It can be anything. It can be evidence of underground storage tanks. It can be chemical storage. It can be an industrial process. It can be a historical use. For example, you're reviewing a city directory and you see dry cleaner, in 1940. Well, that would have to get brought into it. And, there's really, you're doing that look back to see what could possibly have been done at this property to get wrapped into that phase one.
Mm-hmm. Right. And the state has some protections for certain transactions that fall within the ISRA, the Industrial Site Recovery Act. They almost mandate a certain review by the DEP, right? But that depends, I believe, on the SIC code, right? So if you were like a dry cleaner or an automotive body, service or repair, that might trigger it, but not everything is going to trigger ISRA. So, but that adds another layer of protection, I guess, to the buyer by the state mandating that the seller go through. I guess, want to talk a little bit about what ISRA entails?
Yeah, ISRA is a biggie. So it started in 1983, where there was just too many industrial properties that were closing up shop, and then there was tons of contamination, and no one left to actually foot the bill to clean it up.
Right.
So, starting in 83, if you're going to cease operations, sell the property, have various triggering events, you would have to comply with ISRA if you have certain industrial operations. And so that you complete a preliminary assessment report, which is similar to a phase one, but more in depth, and it complies with DEP standards. And you identify areas of environmental concern. So it's different than a recognized environmental condition because, if there's just simply a drum on a property and it's in good condition, it's an area of concern. It might not be a wreck because it might not be spilled. It might be in good condition. But you identify different areas of concern, and then a licensed site remediation professional like Kassidy would determine whether or not additional action is warranted.
And it's important to consider the DP no longer makes ISRA determinations anymore. So the person that owns the property actually has to say, yes, I have to comply with ISRA because of the nature of my business. And the other thing to know about the process is that you have to identify and close all identified areas of concern. It's not like a regular property transaction where you just focus in on one or two things. If it is an ISRA applicable property, you have to go through the 20 or 30 things that you find and decide, is there a problem, is there not, and still close all of them eventually.
Now, does the state rely on the LSRP, like yourself? Somebody, if the seller hires them, do they entrust you with making the shots about what the steps are that need to be done to close each of those 20 recognized areas of concern? And the methodology, like let's say it's a dry cleaner, former dry cleaner, there's groundwater contamination. The consultants will come up with a plan, and then you're going to have to review it and approve it. And then if you give the stamp of approval, the transaction can go through as long as that remediation plan is put into effect.
Exactly. We're not here to stop or slow down deals. Those deals can still go through with our involvement. But yes, you'll have someone like myself review those plans and go through and say, yes, this area of concern is in compliance, or it needs further delineation or remediation with an eventual plan for closure later. And those things can all get worked out in the contracting phase.
Yeah. So the LSRP, I mean, that's a really very powerful position you're in. You're like the eyes and the ears of the DEP to an extent, right? Because DEP doesn't have the manpower to go out there and physically, hire their own staff. So they entrust people like yourself, trained professionals, with that task. So
right, that's really the basis of the license is to entrust qualified people in the industry. They have the knowledge, they have the experience to be able to evaluate these sites and say, yes, this site is okay, or okay, there's these few things that need to happen, or wait, we actually need to do a real remediation here.
Yeah.
So there is a lot of trust there.
Yeah. Now, I guess we should also, before the break, we're going to give your contact information, but if you're hired as an LSRP for Peak, then I presume that due to conflict of interest, could your firm also do the remediation under your guise, or if you're hired by if Peak Environmental is hired to provide an LSRP, does the remediation firm have to be separate, a different firm, or can it be done within your guys?
No, it can be. It can be done all in one location. We've actually done property transactions where we function as the LSRP for both the buyer and the seller, as long as they both agree that can happen. So no, you don't have to have someone separate from the LSRP to complete the investigation or remediation. Some people choose to do that just as an extra layer of oversight, but it's not very common.
Okay.
Because everybody have the same standard again.
Yeah.
And especially the engineering type of the consultation company, they just go by the book. Good news or bad news, they just tell you what it is, right?
Whether you want to hear it or not,
just
right?
like our residential side, like a home inspector, good or bad, they tell you. And then if they discover some issues, if it's electrical, you got the electrician. Once again, plumbing, got a plumber. They just come tell you what they think.
Yeah,
right.
And believe it or not,
that's true.
They could be wrong, but they don't intentionally. They just tell you what do you think. Good news, bad news. They get paid. That's what they come to do, give the expertise.
And even on the
so it doesn't matter. It's the same standard.
Right. Even on the residential side, we're still encountering underground storage tanks. They're not gone. They're still in the ground. You've encountered them on the in the central Jersey area.
Yeah.
I was told they'd be gone by now, but that's apparently not true.
Not true. Maybe another 30, 40, who knows, right? There's a lot of tanks that were put in the historically.
But at least it's a water storage tank. It's a septic or something. It's not oil tank. Every time you hear oil tank, my face change color.
Yeah. I just had a commercial property that had one. When they did a tank sweep, they actually found two of them they had to remediate. And
it happens very frequently.
Yeah. We're going to go to break soon, but please give your contact information for Peak, and so anybody can get in touch with you.
Sure. I can be reached either through my phone, 732-379-0672, or email me at Kassidy.Klink, Kassidy, .Klink, at novagroupgbc.com.
All right. Thank you guys very much. We're going to take a quick break. We'll be right back after these messages. Okay, welcome back to our show. So Kassidy and Jacqueline, we were talking about the phase ones and the fact that if issues come up that are known as recognized environmental areas of concern, that's not good news. Meaning, so talk about the next steps that could happen once you've identified a property that has, I guess you would call it the acronym, environmentally recognized environmental concerns. Is that it? EREC is the acronym? Or
recognized environmental condition for phase one.
Yeah, I always get, okay.
Or area of environmental concern for PAR. I know.
Oh, that's right. and the recognized, and then the one for the phase one, which is a recognized environmental concern, is more of a red flag than an area of concern under the PAR, because area of concern, like you said prior to the break, that could be a drum storing some chemicals, but there's no evidence that it's leaking. It's
right.
Perfectly intact. But a recognized environmental concern is something where there's been some evidence, like we said, about distressed vegetation, underground storage tank, asbestos, maybe historical use of dry cleaning or something. So let's talk about now. If you have that report, then do you guys come up with another recommendation of how to further investigate those concerns?
Yeah, our recommendations in the report would typically be to perform a phase two if there's any wrecks identified. Oftentimes the first step is maybe doing a geophysical survey, which might be to scan for underground storage tanks, or it might be to clear utilities if we're going to be doing borings just for safety purposes. And then we would be on site with a driller to advance soil borings, to collect samples, to bring to a lab so they can do analysis and really see if there's any contamination at a property. Sometimes there's also groundwater samples collected or vapor samples, but oftentimes the first step involves soil sample collection.
Right. We had a project together somewhere in Jersey in the Hunterdon County where there was a recognized historical use of herbicides.
Okay.
So we did the sampling, and it turned out to be that the site was below the levels, or which was good news. Yeah. So it's not always bad news when you have the recognized environmental conditions or concerns, but you just need to warrant maybe further sampling, right? Like getting a blood result that raises something above the level, but you have to delve further, right?
Yes.
Right. We're always awash in acronyms, though. That's what I always find funny talking about this stuff. But exactly, there's always off-ramps. Going through the process shouldn't be something that someone looks at and says, wow, I really don't want to do this. I don't want to find anything. Even if you do find something, that's not necessarily the end of the world. There are points in time where we can do things on a regulatory basis or just looking at the data to get you to a positive endpoint. Right.
And with real estate, oftentimes there's a lender involved, so that adds another layer of concern and overcheck. And lenders, it's very important. So the work you guys are doing on the phase ones and phase twos is extremely important to the lender who's going to have a vested interest in that property. Talk a little bit about how the financing plays into it based on the environmental concerns and how the lenders get involved in giving their 2 cents on it.
A lot of times we find that if there's contamination identified during the phase two, the lenders will want that to be delineated. They'll want to have enough information so that way a remedial cost estimate can be prepared to have a general idea of the big picture of what it might cost to remediate it. So if there's a tank, for example, that needs to be removed, you might have like a reasonable worst case scenario of what it may cost to remove it, and if there's soil impacts or groundwater impacts. But every lender is different, so sometimes they may require more, sometimes they may require less. It just depends.
Right. Okay. And let's talk now also about the New Jersey DEP spill reporting requirements and when that's triggered and if there's proposed changes to that. Why don't we start with the current rule and the obligation of somebody like a third-party professional, an LSRP, or somebody like yourself, Jacqueline, an environmental professional, if you recognize that there's a spill on a property that you've been hired to do a phase one for on behalf of the buyer, what are the reporting duties to the DEP currently?
Right. So historically, if we were to come onto a property, unless there was something that's of immediate concern, it wouldn't immediately trigger a reporting obligation. You might be involved in a transaction where they allow you to do the sampling, but say, we don't want to know the results. Or you give them to your side, counsel, et cetera, and they're in charge of disseminating that information per whatever the agreement is. The DEP wanted a change. They think that there's thousands of unreported environmental cases in New Jersey that are found during due diligence that people are choosing not to call into the state as a spill. I don't quite think the issue is as dire as they claim it is, but that is their position. And they were pushing for an expanded spill reporting requirement where anybody with any knowledge of a spill would have to make that call into the state. So it could be anybody from the person out in the field collecting the sample. They see something that looks like a release, they'd have to call that in. The lab technician who sees something from a sample run that's slight detection, they'd have to call that in as a spill. The environmental council would have to call in a spill. You as the real estate agent, if you had knowledge that there was a spill, you'd have to make that call into the state. And this is what they were pushing for until very recently. Obviously there was a lot of pushback from people like myself, other people within the industry, other groups that had a vested interest in this not going through, because our feeling is that there would be a huge freeze on property transactions. And not only that, but not many people would want to have samples collected at that point or even a site inspection, because you could not risk that transaction not going through. Imagine you set up a deal and then someone calls in a spill and causes a huge liability to come onto the books, and you don't have the money for that. I believe, and a lot of people believe, that people wouldn't risk the transaction at that point.
Would the call be triggered if the sample exceeded one of the parameters? It would have to be like, let's say you have TPHC, total petroleum hydrocarbons,
Right.
but if it was below whatever the current limit is, or VOCs, would it be triggered only if the contaminant is above the DEP level, or is it triggered if they visually see there's oil in the sample?
Honestly, it would be anything, because the DEP views there to be no de minimis quantity. So their view is in the legislation, even if you have a detection, that is technically a spill. Now, many LSRPs, environmental professionals, don't believe that to be true. They view it as there are cleanup standards for a reason, and some of the compounds we deal with, they can naturally occur. Like, for example, if you get a silver detection in the environment, silver actually exists out there. So who's to say that detection is natural, or is that a release?
I was going to say, next time I go to the gas station, when the attendant, if they've overfilled the tank and they drop the gas strips, that's
every
a spill.
single time.
Yeah, so how many of those spills would be literally that would qualify under the letter of the law. That would qualify as a reportable spill to DP if this proposal, I guess, comes to fruition, right?
Right, and thankfully, saner heads have prevailed. There was some discussion with the department. Several groups submitted letters to the state saying, guys, we don't believe that's a great thing, and honestly, we don't believe you had the authority to require that. So the compromise that has come out is that if we do find something, we are obligated to tell the responsible party, the seller of the property usually, about that information. And they are required by law to then make the call in. Whether that happens or not is not on our shoulders, which is good, because removing qualified environmental professionals, particularly LSRPs, from property transactions is a huge negative. You're losing a lot of experience in these transactions if you kind of handcuff us and exclude us from deals. But with this compromise, we can still stay involved, give the PRCR, the person responsible, or / the seller, the information, and they can make that choice. Am I going to comply with this law? Am I not? Am I going to wait for the transaction to proceed, et cetera?
Right. And also the protections of the buyer is there, because they're hiring environmental professionals like yourself that are going to check the site, and if it warrants a phase 2 sampling, you're going to do the phase 2 sampling,
Yes,
and then determine whether or not there's any parameters that exceed the guidelines for the DEP, whether for anything. So the protection is already in place, and I think calling it in would just give it a case number, and then that case number would, I guess, go on the record, and it would have to be closed out by the LSRP, right?
Right. Usually with these contracts, it gets laid out who is responsible for what, who pays for what. Typically, there's things like money set aside in an escrow to pay for certain aspects of remediation. It might be agreed upon that the seller only handles things up until they are able to obtain a permit, and then long-term permit requirements or costs, that's on the buyer. You might have an environmental insurance policy included. So there are ways to assign who pays for what, who's responsible for what, with the understanding of who has technical liability at the end of the day.
Right. The insurance kicks in, right? Because even if the seller stays on the hook for it, if the seller leaves, or you have to have something with stronger teeth to tie the seller in, whether through an insurance policy that's in place to cover the cleanup, which could take, I guess, cleanup in some cases can take years, right? Depending on what type of parameter you're trying to clean up, if it's in the groundwater. I don't know. How do these dry cleaning compounds, the old ones, how do they clean up from the groundwater? Is it a long, arduous process to get them out?
So there's really two pathways to go with that. There's the natural approach, and then there's the active approach. Natural approach is a lot of these dry cleaning compounds naturally degrade over time if the right microbes are in the subsurface. So those microbes will use those dry cleaning compounds as food and degrade them over time, transforming them into non-hazardous substances. It doesn't happen quickly, and it may not happen at all if those microbes aren't around. Thankfully, there are options. We have many different active technologies that can degrade or remove that contamination from the subsurface so that you get those concentrations below standard.
Pretty interesting, yeah. Let the microbes do the work and natural attenuation, right? Yeah. Or you can do what is like pump and treat. Pump and treat is if you take the groundwater out and then you pump it and treat it through something and reintroduce it back into the...
Right. Pump and treat has been around since the environmental industry has been going, but that's exactly what it is. It's you pump the contaminated groundwater out of the ground, you treat it on the surface, and you re-inject it into the ground. We don't typically do that anymore just because it is a huge expense, and it honestly takes much longer to remediate a site than other technologies. Sometimes we'll inject our own microbes that are proven to degrade these type of compounds. Sometimes we'll use more of a chemical technology to degrade them instead, but there are many different options. And like what Jackie was talking about with doing these kind of cost assessments, we'll look at many different technologies and approaches and show, okay, if you want to go fast, it's going to cost this amount, and if you are okay with spending more time, it will cost this lesser amount, but you'll have to take more time to do it. So we provide those options based on the information that Jackie and her group might obtain during phase 1 or PAR.
I just have a silly question. If you pump the water out, right? I mean, my thinking is if you pump out, the water is underground, so the other place water may come in.
Well, displace it, she's saying.
How are you going to pump it out?
Well, right. Yeah, the subsurface is not static. The groundwater beneath our feet is always moving. And, when you have contamination in the ground, it's typically not just in the water. There's usually contamination adhering to soil particles, and that's contributing to that groundwater contamination. So even low-level soil contamination can cause a long-term groundwater issue. So when you pump that groundwater out, yes, clean water will come in, but it'll get contaminated from that source
But you
material.
also remediate the soil in that case. If you know the soil is contaminated, you're going to probably take out a certain amount of soil and put it back with certified clean to fill, and then do the ground. They're not going to leave any contaminated soil in place. Otherwise, you're you'll just be continually to pump the groundwater when the soil contaminants get into it, right? So you want to treat it both the soil and the groundwater as part of the process.
Exactly, but there's a threshold. We can't treat, or we very infrequently treat to absolutely clean. So you're still going to leave some type of contaminated material in place. It's just what's that threshold that you need to get it to so that groundwater can either clean up naturally over time or doesn't recontaminate after you've done a remediation. That's the last thing someone wants to do, is spend a lot of money on a remediation and then come back out and, oh, wow, it's still contaminated. You don't want that to happen.
Wow, this was really interesting. We are just about out of time. We want to thank you guys both for being our guests on the show. And once again, please give Peak Environmental's contact information. And we want to, again, thank you for being a generous sponsor of the East Brunswick Regional Chamber of Commerce.
Thank you so much.
Thank you for having us. My contact information is my cell phone is 732-241-8905, and my email is jacqueline.ulrich@novagroupgbc.com.
All right, very good. Hope everybody enjoyed this show and have a great rest of the weekend. We'll see you next week.
Thank you
Thank
both.
you.
Thank you.
Take care.